Hey there, ready to test your knowledge? Let's test your knowledge on 2026 Illinois PSI exam 60 questions and answers explained. Question 1. Mr. and Mrs. Cox make Mr. and Mrs. agreeing an offer on their home, but they have not heard back from them on whether or not the offer has been accepted. In the meantime, they have found another home they would like to purchase instead. What is their best option? A. Withdraw their offer with penalty. B. Modify their offer to one they are confident Mr. and Mrs. Green will not accept. C. Withdraw their offer with no penalty. D. Wait for Mr. and Mrs. Green's response. If they accept the offer, pay the withdrawal fee outlined in the contract. The correct answer is withdraw their offer with no penalty. Withdraw their offer with no penalty. Before an offer has been accepted, the buyers have the right to withdraw their offer with no penalty. However, if the seller has already accepted the offer now becomes a contract that carries with it legal obligation. Question 2. Reversion of title is a feature of what type of interest? A. Fee simple. B. Fee simple condition precedent. C. Fee simple condition subsequent. D. Fee simple determinable. The correct answer is fee simple determinable. Fee simple determinable. You may have been tempted to answer fee simple condition subsequent, which allows the right of re-entry, the grantier's right to go to court to reclaim the property. In fee simple determinable, the title reverts back to the grantor if a certain condition isn't. Question 3. The lumber for a deck that has not yet been built is A. Personal property. B. A fixture. C. A trade fixture. D. Real estate. The correct answer is personal property. Personal property. Personal property is tangible, movable, and not permanently attached to real estate. The lumber can become a fixture and therefore real estate if the deck is built. A trade fixture is something used in conjunction with a business. Question 4. The transfer disclosure statement (TDS) form is required on A. The sale of A. 1 to 4 unit residential property. B. The sale of a commercial building. C. All foreclosure sales. D. The sale of vacant land. The correct answer is 1 to 4 unit residential property. The sale of a 1 to 4 unit residential property. Many disclosure laws target 1 to 4 unit residential properties as a protected class of real estate. As the transfer disclosure statement (TDS) form is completed by a seller regarding known facts, it is not required in the instance of a foreclosure. Further, commercial property transactions require the disclosure of property defects affecting value, but the statutory TDS form is not required. Question 5. When a purchase agreement states the property is being sold as is, it still requires the buyer to receive A. Transfer disclosure statement (TDS) noting any material facts which affect the property's value. B. Puts the buyer on notice they should beware. C. Underscores the fact that nothing is warranted. D. Releases the seller of the requirement to deliver a TDS to the buyer or make any disclosures about the condition of the property. The correct answer is transfer disclosure statement (TDS) noting any material facts which affect the property's value. Still requires the buyer to receive a transfer disclosure statement (TDS) noting any material facts which affect the property's value. Assess is a nebulous and frequently misunderstood statement in real estate practice. A transfer disclosure statement (TDS) containing property information including known or suspected property defects affecting value is required to be delivered to a prospective buyer on the sale of a 1 to 4 unit residential property as soon as practicable on the commencement of negotiation. Question 6. An unlawful detainer UD action is instigated by A. The grantor. B. The trustee. C. The lessor. D. The real estate broker. The correct answer is a lessor. A lessor. An unlawful detainer UD action is the court procedure to force a tenant to vacate the rental space they do not have the right to possess. A lessor landlord is the aggrieved person who initiates this process against an individual who holds no right to occupy a property, such as a holdover.